Okay, so good morning, everyone. Our topic for today is about Republic Act number 9775 or the Anti-Child Pornography Act of 2009 or 2009. So, an act defining the crime of child pornography, prescribing penalties, therefore, and for other purposes. Be it enacted by the Senate and House of Representatives of the Philippines in the Congress assembled. Okay, so based on the child pornography in the Philippines now, statistics, there is scant data available on child pornography, and these statistics do not present the actual extent of the problem. So based on what we have here in our table number 1, it reported case of victims of child pornography as compared to victims survivors of child prostitution. So for victims of pornography by 2000, that is 9, 2001 in 4, 2002 in 7, and 2003 is 13. For the victims of prostitution, we have 86, 186, 224, 245, and 247. But now, based on the volume of the SPR submitted to AMLC, based on the figure 1 here again also in the yearly volume, as you can see, for the child pornography, associated with child pornography. So as you can see, by 2020, that is 27,000. So a while ago, it's just only 2003 is just only 247, right? 13 for victims of pornography. But as you can see here, by 2015, that is 204, 2457, 13606, and 2019 is 10,000. And for the first semester of 2020, that is 27,217. Okay? Now, so pedophilia and child pornography in the Philippines. The need for anti-child pornography legislation in the Philippines, particularly in relation to an internet, in the role of the Philippines as a producer by cybersex and child pornography in cyberspace. So the internet regulatory situation prior to RA 9775, the situation obtaining prior to passage of the act, both as regards to child abuse, okay, for child abuse, that is RA 7610, and regulation of the internet, that is RA 8792. The Anti-Child Pornography Act of 2009 express goal of guaranteeing the fundamental rights of children from all forms of neglect, cruelty, and other conditions prejudicial to their development, protecting them from all forms of exploitation, including their use in pornographic performance and materials in their inducement or coercion to engage or be involved in pornography, and complying with international treaties concerning the rights of children to which the Philippines is a signatory or a state party. Okay, so the Declaration of Property, actually, the state recognizes the vital role of the youth in nation building and shall promote and protect their physical, moral, spiritual, intellectual, emotional, psychological, and social well-being. Toward this end, the state shall guarantee the fundamental rights of every child from all forms of neglect, cruelty, and other condition prejudicial to his or her development. Protect every child from all forms of exploitation and abuse, including but not limited to the use of child pornographic performance and materials, as what we have here now, and the inducement of coercion of a child to engage or be involved in pornography through whatever means. Comply with international treaties to which the Philippines is signatory, as I mentioned, or a state party concerning the rights of children, which include but not limited to the Convention on the Rights of the Child, the optional protocol to the Convention on the Rights of the Child of the Child on the Sale of Children, child prostitution, and child pornography, the International Labor Organizations Convention number 182, on the elimination of the worst forms of child labor and the Convention Against Transnational Organized Crime. Okay. Of course, child refers to a person below 18 years of age or over, but is unable to fully take care of himself or herself from abuse, neglect, cruelty, exploitation, of discrimination because of a physical or mental disability or conditions. For the purpose of this act, a child also referred to a person regardless of age who is presented, depicted, or portrayed as a child as defined herein, and computer-generated, digitally or manually crafted images or graphics of a person who is represented or who is made to appear to be a child as defined herein. Child pornography refers to any representation, whether visual, audio, or written combination thereof, by electronic, mechanical, digital, optical, magnetic, or any other means of child engaged or involved in real or simulated explicit sexual activities. Explicit sexual activity includes actual or simulated. As to form, sexual intercourse or lascivious act including but not limited to contact involving genital or genital, oral to genital, and anal to genital or oral to anal, whether between person of the same or opposite sex. Bestiality, masturbation, sadistic or masochistic abuse, lascivious exhibition of the genitals, buttocks, breasts, public area and or anus, or use of any object or instrument for lascivious acts. Internet address refers to a website, bulletin board service, internet chat rooms or news group, or any other internet or shared network protocol address. Internet cafe or kiosk refers to an establishment that offers or proposes to offer services to the public for the use of its computers or computer system for the purpose of accessing the internet, computer games, or related services. The internet content host refers to a person who's host or who proposes to host internet content in the Philippines. The internet service provider refers to a person or identity or entity rather that supplies or proposes to supply an internet carriage services to the public. Grooming refers to the act of preparing a child or someone who offender believes to be a child for sexual activity or sexual relationship by communicating any form of child pornography. It includes online enticement or enticement through any other means. Luring refers to an act of communicating by means of a computer system with a child or someone who the offender believes to be a child for the purpose of facilitating the commission of sexual activity or production of any form of or any form of child pornography. Then bestiality. Pandering refers to the act of offering, advertising, promoting, representing, or distributing through any means of material or purported material that is intended to cause another to believe that the material or purported material contains any form of child pornography, regardless of the actual content of the material or purported materials. Of course, person refers to any natural or juridical entity. Now, unlawful or prohibited acts. It shall be unlawful for any persons to hire, employ, use, persuade, induce, or coerce a child to perform in the creation or production of any form of child pornography. To produce, direct, manufacture, or create any form of child pornography. To publish, offer, transmit, sell, distribute, broadcast, advertise, promote, export, or import any form of child pornography. And to knowingly, willfully, and intentionally provide a venue for the commission of the prohibited acts such as but not limited to dens, private rooms, cubicles, cinemas, houses, or an establishment purporting to be legitimate business. For film distributors, theaters and telecommunication companies, by themselves or in cooperation with other entities, to distribute any form of child pornography. For parent, legal guardian, or person having custody or control of a child to knowingly permit a child engage, participate, or assist in any form of child pornography. To engage in the luring and grooming of a child. To engage in pandering of any form of child pornography. To willfully access any form of child pornography. To possess any form of child pornography and to possess them with intent to sell, distribute, publish, or broadcast, provided that possession of 3 or more articles of child pornography of the same form shall be prima facie evidence of the intent to sell, distribute, publish, or broadcast. In addition, the Act also dictates it's unlawful for film directors and for parents, as I mentioned earlier. Prior to this, I just want to discuss the syndicated child pornography. No? The crime of child pornography is deemed committed by a syndicate if carried out by a group of 3 or more persons, conspiring or confederating with one another, and shall be punished under Section 15A of this Act. Who may file a complaint? Complaints on cases of any form of a child pornography and other offenses punishable under this Act may be filed by the following: the offended party, parents or guardian, ascendant or collateral relative with the third degree of consanguinity, officer, social worker, or representative of a licensed child caring institution, of course the DSWD, local social welfare development officer, barangay chairman, any law enforcer officers, and at least 3 concerned responsible citizens residing in the place where the population occur, and any person who has personal knowledge of the circumstances, the commission of any offense of under this Act. So duties of internet service providers. Okay, so monitoring, mandatory reporting. So violates principle of ISPs as public utilities. ISP no have broad, discretionary, and warrantless surveillance powers. No limits on ISPs use of monitoring and information for other purposes, commercial, marketing, and profiling. Duties of ISPs, mandatory data, of course, retentions. So as what we have here, no specific nor limits on the information that ISP may collect, assume any at all. No safeguards nor time limit on storage of subscriber data or information or forever. And no safeguard against commercial repurposing or trading of subscriber data. Or attempted to gain access, of course, personal information available upon request. No warrant, court order, or any judicial required review required. Okay, so the mandatory filtering, of course, excuse me. So legitimizes filtering and prior censorship of internet content, and so on. So safeguards of civil liberties and consumer rights, ISP are provided immunity from civil suit. No? Overly broadened discretionary power are vested in Anti-Child Pornography Council. Duties of internet content host. So this will be the duties. No, internet content hosts are prohibited from hosting any form of child pornography. To report within 7 days the presence of any form of child pornography. To preserve such evidence of purposes of investigation and prosecution by relevant authorities. Comparison to model legislation, absence of blocking provision, global norm is voluntary filtering. For surfacing tension, we have defining pornography as a while ago, and we have vesting powers and an overseer. So, reliance on technological solutions. So that is rarely work. Vested powers in commercial vendors of technology lock people into proprietary technologies and vendor capture and grab. Then anonymity of the internet, privacy and handling of personally identifiable information. So we have the privacy in the Philippines actually. Okay, so we had habeas data in common rights to privacy, constitutional provision, civil codes, of course, Tanyada Wiretapping Act, E-commerce Act will be presented late next time, no? E-commerce Act, and the Cyber Prevention Act of 2012. It must be discussed, no? Because as an IT practitioner, we need to know the E-commerce Act and the Cyber Crime Prevention Act of 2012. Strands of privacy and standard for intrusion, locational or situational privacy, informational privacy, decision privacy. No, the standard for a valid intrusion to privacy is either a valid warrant or lawful order by a court or a law prescribing such intrusion based on public safety or public order. So this will be the existing legislation. So we have also anti-wiretapping law. Maybe somebody from the group assigned to discuss this anti-wiretapping law. Electronic Commerce Act with an anti-photo and video or Act 2009. Data Privacy Act, we're done it already. And the Cybercrime Prevention Act. So contentious legal issues. So as what we have here. So other questions when it comes to technical issues, efficacy of filtering, public website versus private exchanges, filtering as palliative, commercial interest of ISPs, and RA 9775 implementing rules and regulations. How about the issues, concern, and legislative measures for RA 9775? This is done actually by Wag Yuayan, Rachel. Okay. Cybersex actually is a multi-billion-dollar industry. It preys on the young and economical vulnerable in society. It enriches the recruiters and operators of the industry while it robs the child victims of their innocence and youth. Okay, so gaps in law relating to child internet pornography. Prior to the passage of RA 9775, various child advocates and government authorities have emphasized the need to review and reassess the Philippine laws dealing with child pornography. They posited that said laws, particularly RA 7610, an act providing or stronger defense of special protection against child abuse, exploitation and discrimination, and for other purpose and others. No, the absence of the specific law criminalizing possession of child pornographic materials and its trade via the internet and other media has caused a lot of cases on child pornography to be dismissed. The Philippines ratified the optional protocol for the Convention on the Rights of the Child on the Sale of Children, Child Prostitution, and Child Pornography last May 8, 2002. As a consequence of treaty incorporation, by virtue of the principle of Pacta Sunt Servanda, the Philippines was obligated to enact an enabling legislation. Okay, the same protocol will also state that the elimination of child pornography with the facilitated by adopting a holistic approach and addressing the contributing facts, including underdeveloped, poverty, economic disparities, inequitable socioeconomic structure, dysfunctional families, lack of education, urban or rural migration, gender discrimination, irresponsible adult sexual behavior, harmful traditional practices, armed conflicts and trafficking in children. Thus, such factors should be factored in the legislative measure. So, lapses in law enforcement, there is a growing international acceptance of the need for more effective action and strengthened law enforcement in this jurisdiction. This would require the ability and capability to monitor the enforcement of in this jurisdiction, as I mentioned. Okay, again, this will be required the ability and capability to monitor the situation closely as possible. The difficulty surrounding the circumstances of the child victim possess the inability to report the cases personally injured by him or her, given the cultural boundaries that our country represent. Therefore, keeps child pornography out of sight for a long time now. Weaknesses of the Philippines judicial system resolved by RA 9775. In the case of the Philippines, prior to the passage of this RA 9775, there was lack of integrated and well-informed set of laws on child internet pornography. Amidst the fast-paced advancement in technology, it is difficult to pursue cases in the Philippine courts, particularly those pertaining to cyber sex crimes, such as online pornography, in the absence of any law defining it. The protracted process of prosecution, given the absence of available laws and the difficulty in gathering evidence that may be considered admissible in court, are underlying challenges brought about by the complexity of the times. With the new law, the judicial system in this jurisdiction is strengthened as it provides for the prosecution of child pornography cases whereby any person who has knowledge of the commission of any of the offenses under this act, including but not limited to the child, parents, siblings, legal guardian, the DSWD, police officers, and file a complaint for its prosecution in the juvenile and domestic relations court. In view of this, the DOJ shall appoint or designated special prosecutors. In addition of the above, Supreme Court Circular AM number 00407 SC, dated November 22, 2000, or the Rule of Examination of Child Witness and its amendments or revisions thereto, shall be applied in the prosecution of the same. Statistics on child pornography appears deceptive. So the DSWD described the statistical data gathered by their office as extremely low despite the numerous raids conducted by law enforcement authorities. It is widely believed that these figures do not accurately reflect the real numbers of children victimized by internet pornography. Unfortunately, our culture does not associate pre-pubescent children as those that can be had as sexual object. It is only when their parents see them being subjected to actual sexual abuse by the so-called pedophiles that they consider the act as pornographic. Well, this issue has posed a problem in the gathering of data needed for studies relating to the matter. It did not prevent the legislator to finally enact RA 9775. The psychological effect that promotes the sense of brokenness among children demands their self-worth. So child pornography materials or pornographic materials promote the commodification of children in that they are treated as commodities and marketed like sexual objects. This particular practice permits the cycle of abuse to go on among victims and perpetrators of child pornography. In this way, the distorted notion of what is acceptable in society in terms of sexual acts, behavior, values, and partnership is likewise severely affected. Hence, the law provides for the care, custody, of treatment of the child victim through the DSWD by giving support for the recovery and reintegration in community. In relation to this, the right to privacy of the child and his or her family is protected at all times in whatever stage of the investigation or judicial proceedings. The name, address, telephone number, school, business address, employers, or other identifying information of a victim or an immediate family member without the latter consent shall not be published or caused to be published in whatever form of in order not to aggravate the brutality of the situation. The internet service providers refusal to cooperate. So rather expectedly, owner or in representative of the ISP never attended the Senate committee hearings and technical work group meetings. So as provided by the rules, numerous invitations were issued to them given the magnitude of concerns and the undeniable role that ISPs plays in the curbing child internet pornography, but to no avail. Indeed, this lack of support initially posed as an obstacle in the fight against pornography by reason of the privacy protection policies invoked and enforced by these companies. But their continued absences in the proceedings after sufficient notice is recognized by law as form of waiver of their day in court. The child pornography interlinked with other forms of sexual exploitation. During the public hearing in TW meetings, there emerged a consensus that the subject of child pornography should not be separated from other forms of commercial and sexual exploitation of the children. It is interrelated with child prostitution and trafficking. It is therefore important to discuss pornography in the context of other forms of sexual exploitation and abuse to help people understand the pornography, albeit an issue worthy of separate attention, is still anchored upon other forms of sexual abuse and exploitations. Also, legislative measures on child pornography must be consistent with other laws in order to avoid adverse implications on policies affecting child trafficking and child prostitution. Consequently, there had been a holistic, comprehensive, and harmonious approach in the review of all the laws involving children. Now, so being a law of RA 9775, it needs support not only for the Philippine judicial system, the law enforcement agencies such as the police and the military and the local government units, but also the community being at the grassroots of these dynamics. The success of this law depends on the proactive interplay and commitment of these stakeholders, especially the family. Because the family as the basic institution of our society plays a most important role in combating child pornography. The child is helpless without the positive intervention of his parents, brothers, sisters, and other relatives, whom he looks up to for guidance and education. Hence, it is also our obligation not only to the state to mobilize a crusade of the importance of public action to monitor and detect the practice of child pornography in the Philippines. So again, passage of a new anti-crime law with statutory, judicial safeguard, and civil liberties, specifically to expand upon the supersede the relevant section of Anti-Child Pornography Act. Amendment in addition to the data privacy bill that would restrict repurposing of data. Amendments of anti-child porn IRR to provide legal protection, delimit the commercial use of monitoring, and filtering capabilities include other stakeholders. So this will be our references. Thank you and good morning.